going on here? When I began my practice in '67, it was a straight felony, meaning that any amount of marijuana was punishable up to 5 years in state prison. And in 1976, we were able to work with the legislature in California and pass what's called the Margolin bill. And that bill provided for reduction of felonies to misdemeanors, meaning that if you had up to an ounce of marijuana, you would not be subject to any further criminal sanctions, but for a $100 fine, maximum sentence, and with no probation. So in California, it remains that possession of marijuana up to an ounce is a $100 fine maximum. However, if you have more than an ounce, it's a misdemeanor, punishable up to 6 months in jail. And of course, if you possess it for sale, it is a felony. That's punishable up to 3 years in prison. Cultivation is punishable for up to 3 years in prison. It still remains any plant that you grow is punishable by a felony and up to 3 years in prison. Sales is also a felony in the state of California and is similarly punished by state prison. Then in 1996, we passed through a lot of work and labor and spearheaded by Dennis Perone, we passed Prop 215. Prop 215 was a medical marijuana law that provides that those people that have been recommended or approved by their doctors in California could grow and possess marijuana for their personal medical use. And that was limited to that only, to growing and possessing, not any other activities. And if you have a medical recommendation in California, that is supposed to be the law if you possess quantities for your personal medical needs. There is no standard set as to how much that is. However, under the law, if you possess something that's beyond for the personal needs, then you're subject to the criminal sanctions, albeit usually possession for sale. And that's based upon the opinion of a narcotics officer, generally, of what they believe the quantity represents. So you could be charged with other crimes if you didn't possess for your personal medical needs. Now, that bill that was passed under the Prop 215, the Compassionate Use Act in 1996, was again limited to only growing and possessing by patients and their caregivers, meaning that caregivers could grow and possess the marijuana and they could provide it for the patient. But things like transportation, for example, was currently not considered in the statute and wasn't designated in the statute. And the courts limited that kind of activity to very strict terms. As a matter of fact, one court suggested that although transportation might be implied in the statute, it would be only, in their opinion, under the guise of a nurse taking the marijuana from the garden to the patient's room in a hospital. That's the only kind of transportation they would think would be appropriate. So through a lot of concern over what was happening in the streets and how people were being treated and arrested, they passed in 1995 the Marijuana Program Act, which provides, they passed in 2005 the Marijuana Program Act. It was instigated by and spearheaded by a senator in San Francisco, out of San Francisco. Actually, I think of his name for a moment. Give me a moment. Let's start all over again. In 2005, the legislature passed the Marijuana Program Act, and that provided for a lot of extensions and expanded the Prop 215, including, amongst other things, it provided for the issuance of registration cards from the county health departments, which would be recognized by the police so that people would not be subjected to arrest and confiscation of their marijuana. Because up to that time, and even today, police officers do not have to, nor do they typically recognize simply a letter from a doctor. They want some authority to issue cards so that they know that this has been authorized by the county health department. Now, unfortunately, many counties have not issued those county health department cards, notwithstanding promises and promises and promises it's going to happen next month and next few months. And therefore, we're stuck in something like in LA County, where we still don't have those cards issued. So people are still subjected to being arrested and their marijuana confiscated because all they can show is the doctor's recommendation. And that doesn't necessarily have to be recognized by a police officer because it's not an official document and doesn't have to be considered to be sufficient to prove that they have actually been recommended marijuana or been approved by their doctor. But it's on an ad hoc basis. Some cops say okay, some cops don't. It's a very bad situation. And we have that in many counties here in Southern California. And it's much to the chagrin of the people that are being arrested and subject to confiscation. And also, these poor people that are sitting in their hospital beds and concerned about their physical welfare are still concerned about the potential of being arrested because they don't have a fail-safe card that would protect them. But nevertheless, the statute did provide for the issuance of these county health department cards, and they have been issued in a number of counties throughout the state, in Northern California in particular, and that has helped alleviate some of these problems. Additionally, the Marijuana Program Act provided for transportation of marijuana. It provided for cultivation of marijuana, which already was in 215. It also expanded the definitions of what was protected. For example, typically a person who might be charged with possession for sale who had 6 or 7 ounces of marijuana. Well, under the Program Act, it provides that a patient can have 8 ounces of marijuana and be considered in the safe harbor. If you have 8 ounces or less, you're supposed to not to be prosecuted. You're not supposed to be arrested. Additionally, you can have up to 6 mature plants or 12 immature plants. And again, that's supposed to be a safe harbor. We're supposed to protect patients from being arrested or their marijuana confiscated. And it does work in many cases. And even in Southern California, in most counties, they recognize those safe harbor amounts. And so if somebody is arrested or the marijuana is confiscated, oftentimes they won't be prosecuted. Now also, that 8 ounces of marijuana we're talking about is only supposed to be the buds or the flowering tops. So people may have more with the shake and the things that are left over and all the leaves and stems. That's not considered to be part of the 8 ounces that is protected under the Marijuana Program Act. Now, there's been a lot of resistance to the Marijuana Program Act. As a matter of fact, San Diego County District Attorney's Office brought a lawsuit trying to defeat their duty to issue these cards for openers. And they went to federal court, and they were thrown out of federal court. And just recently, the last couple of months, I think the last maybe 2 months or less, they were also thrown out of state court. And the court held that the Marijuana Program Act and the marijuana laws in California can exist alongside the federal laws that prohibit marijuana, okay? And that it's proper for the California courts and for the authorities to enforce the will of the people and to provide for the protections of the patients and their caregivers. And that is very important to know because up till recently, for someone like myself, people would come in and say, what about dispensaries? What do you think of those things? What do you think? What's your advice on them? I was very reticent to give them any advice about dispensaries because it violates federal law for openers, okay? But with this new ruling by the court that it makes it clear that these laws can coexist, it's clear that we can help those people that wish to help other patients by putting together co-ops and collectives and dispensaries. And although I am a criminal lawyer and don't really engage in business law, I do direct people to people that can help them. So nevertheless, now we have a situation where we do have the Marijuana Program Act, which is called Senate Bill 420, which is kind of a coincidence. It was named Senate Bill 420. It happened to be the next one up on the deck, and it came out with number 420. And as you may or may not know, 420 has become an underground expression for using marijuana. It's an expression that has been kicked around for about 10 years now. The first time I heard it was up in Oregon at a gathering called the Reggae on the River. And there they indicated that 420 was a code the cops used when they saw somebody partaking of marijuana use in public. He said, I got a 420 there, you know? Or like you have a 211, like robbery, it was a 420. Other people suggested the expression 420. You care about this? Want to hear about it? Of course, yeah. Okay. Other people suggest that the expression 420 comes from the time that Albert Hoffman uh, who was the discoverer of LSD, came on to his LSD experience at 4:20 in the afternoon in Switzerland when he was riding a bike. I think that's a little tenuous myself. Other people suggest the expression 420 comes from the 420 cannabinoids that supposedly exist in marijuana. I think that's also very tenuous. I do believe it probably came out of that expression of the cops making busts using that code word. Or the final interpretation is that, you know, tea time's 4 o'clock in Europe, and 4:20 is like 20 minutes late for stoners, you know, so maybe that's what it came out of, you know, 20 minutes after 4. But nevertheless, Senate Bill 420 provided for this Marijuana Program Act, and that is a very big umbrella, and that includes all kinds of activities related to marijuana, including co-ops and collectives, which is specifically authorized, which means marijuana users, patients, could come together and grow their herb together. And if they grow, you know, 250 plants for 300 patients, that's protected, for example. You know, they can't be charged with possession for sale. They can't be charged with, cultivation for non-personal use. That's the purpose of the act, to protect those kind of activities. But there's an ongoing debate about really what the patients are doing. Are they really doing it for their personal medical needs? Are they selling to non-patients? Are they doing it for profit? Because profit wasn't authorized under the law in SB 420. It specifically said that profit was not to be authorized under the law. Now, when they say profit for the things like dispensaries and co-ops and collective, the courts have interpreted that to mean it's something in excess of reimbursement for the cost of time and expenses and all the other things that may be involved with providing marijuana to patients. So profits beyond things of typically, which is reimbursement for your time and expenses, reasonable reimbursement. And so therefore, that's still a gray area, what's considered profit or not. And matter of fact, I represent a lot of dispensaries that have been arrested after the fact. I don't represent them before the fact, but after the fact. And almost in all cases, we've been able to convince the DA not to go forward. But I understand this coming week, there's going to be a conference with the DA's office about which dispensaries they feel are appropriately to be prosecuted. And that's going to be probably based upon which ones are going beyond the excesses of simple reimbursement. You know, they don't want to see high profits be made by these dispensaries, which has happened in the past. Some of these dispensaries are bringing in big dollars, and some people have been sitting back as the quotes owners of these dispensaries and bringing in these profits, and that wasn't authorized under law. So I think the DA's office and these police departments are getting more sophisticated in their approach towards it. Of course, generally, the old guard resists anything to do with marijuana reform, okay? They can't believe it's come what it has so far, and they've always been taught and grown up with the concept that it was a very dangerous drug, and it was a stepping stone into the future of use of more hard drugs. And of course, that's been defeated by many studies and the experience we've had now. But nevertheless, the old guard is still shocked by the idea that marijuana is legal in California for patients. And therefore, we have an ongoing feud about these things, such as collectives and co-ops, and whether they're legitimate, whether they're not, and who's running them, and what their purposes are, and how they're being run. So that all that's got to be settled in the prosecution of cases, and ultimately by the courts of appeal when they decide whether or not a conviction is appropriate. We've only had about maybe 15 or 20 cases decided in the courts of appeals regarding the marijuana laws. And almost without exception, they've gone in favor of this expanded act. And they have continually said that the legislature is pretty clear about what they proposed, and that the law does protect these patients and these co-ops and these collectives. And so it's getting better all the time. But unfortunately, the people that are engaged in these activities are on the wave. In a sense, some of them fall into the gully, and some of them don't. And they're taking their chances. And of course, it still remains totally illegal under federal law. Any marijuana is illegal under federal law. But in that regard, the feds only choose to prosecute certain cases, and those are usually big cases involving huge amounts of growing. Usually it's over 1,000 plants, for example, but until that happens, they're not particularly interested. But if they did prosecute these people, for even 100 plants. There's a 5-year mandatory minimum sentence under federal law for just 100 plants. And for 1,000 plants, it's a 10-year mandatory minimum sentence. So we all live in this danger zone that the feds might get more aggressive and decide to prosecute people in the federal courts. However, the experience has been, and almost without exception, that federal judges are not keen on these prosecutions. And in cases involving dispensaries in the past that have been prosecuted in federal court, almost without exception, the federal judges have gone outside the law in the sense of gone to downward departures and basically sent these people home on just minor probation terms, and that's it, almost without exception. Because the courts, I think, realize that most of the people involved with these collectives and co-ops and dispensaries are sincere, legitimate people that are there asking for compassion. Because almost without exception, you'll find the people involved with dispensaries and co-ops are people that do have serious illnesses or know people with serious illnesses, and they were inspired by the idea that they can actually help people in a way where there's little detriment. In other words, you're not giving out drugs that have all kinds of consequences to your kidneys and your liver and all the things that the other pharmaceutical drugs. So I think many people feel this is a legitimate way to serve others. And almost without exception, most of the people involved with these dispensaries and co-ops are people that believe in what they're doing as a humanitarian effort.
Are you familiar with CAMP?
CAMP? Yes. Well, I'm familiar with...
Can you tell me about we need an official, kind of authoritarian type person to explain CAMP.
Well, let me start from the beginning.
Okay.
CAMP is an acronym that I created, okay, in 1967. I was a young lawyer who just passed the bar, and I saw the inequities of the marijuana laws. And I saw how unfair and unjust it was for people that were otherwise law-abiding to be sitting in the jail cells with rapists and robbers and all the abuses in jail. And I thought, I can't believe these marijuana laws provide for these kind of people to be incarcerated like this. And I was in shock. Now, there may have been a couple of organizations before this, but they were not particularly popular, and they weren't promoted very big. And I remember as a young lawyer, I was walking across the parking lot, and I was thinking NAACP, the National Association for the Advancement of Colored People. That's how long ago it was, okay? You've heard of the NAACP. And I was thinking of an acronym for a marijuana reform movement. And I came up with the campaign advocating the abolition of the marijuana prohibition, which was CAAMP, and later changed it to CAMP, the campaign to abolish the marijuana prohibition. That was in 1967. And I created that organization, and I had a lot of people that were joining it, and it was popular. But then in 1973, NORML came on the front, and we had a meeting in San Francisco with people like myself who were heading different organizations, where we agreed that we would go under the umbrella of the national organization so we can make a concerted effort throughout the state and throughout the country. But again, one of the propositions was that we would never give up the idea that people should better grow their own and have complete access to do that. So in 1973, many organizations like CAMP, and Marijuana Program Act, and all these different organizations, about 4 or 5 leaders became part of NORML, and I took over the helm here in Southern California as the director of Los Angeles NORML and gave up CAMP. Now, if you're talking about the CAMP that exists today, which is actually called the campaign, it's called, what's the name of it again?
Campaign Against Marijuana Plantation.
Yeah, Campaign Against Marijuana Planting. CAMP is an acronym for the term the Campaign Against Marijuana Planting. It really came from Van de Kamp, who was a DA at the time. I don't know if you know what Van de Kamp was. He was a DA of Los Angeles, and he came up with that acronym. He was the Attorney General, I think, and then came up with CAMP, the CAMP program. And what it consists of is every year to go out there and rip as many plants as they can out of the ground and defeat the people that are growing it in forests and places like that. And unfortunately, they have impugned the privacy of many people that are not involved with it by helicopters and shootings and things of that nature. So it has done a tremendous disservice to the tranquility of many Northern California counties. And these law enforcement laws here regarding marijuana has been also promulgated violence, because, you know, when you have illegal, it raises the price because of the risk involved. And when you raise the price, then you have people very guarded against it being stolen from them and them themselves being arrested. So they set up booby traps, they set up all these things to protect themselves. And many people that are involved with these national forest grows, which sometimes 10, 15,000 plants, are Mexican nationals, that they bring these poor people in from across the border who have everything to gain and nothing to lose because the lifestyle is so terrible. And we have that problem with these forests being filled with marijuana, and sometimes they have booby traps and people with guns to protect against the rip-offs, and that makes it difficult for hikers. And of course that gives a foundation or gives it some, we say a basis to continue with the program. We're protecting the forest, we're protecting hikers, you know, so it goes on and on and on in a circular way. I mean, obviously, if you legalize marijuana, many of these problems would go away overnight. And again, it would be many reasons why we should do it. We can get into that later, but there's one example of why the laws don't work. So CAMP is this program that continues to exist. Every year, these cops go up in Northern California. They have a wonderful time. They put on their fatigues. They get their helicopters, and they run around the forest and get a lot of overtime pay and rip up these plants. So that's basically what the program's about. Did you read my interview? Read my interview. Hey, kid, read my interview in there. There's another article in my interview, isn't it? Oh, really? It's the other article. It's the other one. There's two of them there, I think, isn't there?
Yes. Can I,
okay, I mean, that's
ask them to try to
yeah.
be a little
Tell them to shut the fuck up. We want to talk about why marijuana remains illegal. It's a very slippery fish, okay? I've often suspected that people like the liquor companies are against legalizing marijuana. As a matter of fact, as a young lawyer, I represented the guy that owns H.A. Reynolds. His grandson was arrested, and I think he now owns a company, you know? But that's just an aside to show you that they use marijuana, but yet they want to discourage its legalization. If you look at a book called The Emperor Wears No Clothes, which is authored by Jack Herrera, and I think he did this in the late 70s, he went back into the archives of the national libraries and found out a lot about why it is and how it was that marijuana became illegal. In part, it's based upon the racial attitudes against the Hispanic Americans and the black musicians in the 30s and 40s, because there was a tremendous amount of anger at the Hispanics in southern United States, because during the Second World War, there was an agreement allegedly between the Nazis in Mexico to have Mexico join the Axis powers in order to get back for the Mexicans the southern part of the United States. It was a letter that was discovered, and that fueled people's feelings about Mexican Americans. And if you look at the congressional record of when marijuana became illegal, like in places like New Mexico, you'll see the racial tones of the people that were arguing why this is a dangerous drug and why it is it should be illegal, and the type of people that use it. So it was really based in part against the racist attitudes they had towards Mexican Americans and the black musicians who are well known to have used marijuana over the years, in which the whites feared because of their shall we say, the fame they were getting as black jazz musicians, and they also equated marijuana use with their activities. So that fueled a lot of the illegalization that happened in the 30s, 1937. And beyond that, if you read Jack Herrera's book, he establishes that people like the Hearst Corporation was also instigated the illegalization by what's called yellow journalism, which consists of blaming marijuana for things like violent crimes and things of that nature. And underlying their purpose was, I've heard, that they had a special kind of chemical for making pulp paper into newspaper from wood. And of course, the hemp paper would be a great competition to that. And I've also heard that the DuPont company, who had nylon at that time, also wanted to defeat the hemp production in the United States, which was great, which was very big. Hemp has been used, as you know, for thousands and thousands of years, and it was encouraged by our government during the war to grow hemp for our troops to be used for things like parachutes and sails and all the things that hemp has been known to be used for thousands of years. And sometimes it's been referenced the fact that George Bush Sr., when he jumped out of the airplanes during the war, he was jumping out of airplanes with hemp-made parachutes, for example, you know? But all that's been defeated by this attitude towards marijuana, which comes out of these racist attitudes towards the people that used it. And also, coincidentally, because of the attitude about marijuana, it was used in the defense in certain criminal cases by people claiming that under the influence of marijuana caused them to commit criminal acts. And that was effective in a couple of cases, and it made great amount of publicity. So then again encouraged the idea that marijuana was a cause of violence, of doing things that were potentially violent, rape and robbery and things of that nature. So that also fueled the illegalization of marijuana.
How close or far are we away from marijuana decriminalization?
I've been saying for many years, 5 years, okay? I've been saying it for almost 40 years now. I've been involved with this. This is the 40th year, okay? And I've been saying the same things over again. But this year I can happily say we're about 6 months away.
Can you say it in a
Why?
complete, because
Okay.
they won't hear my question.
I've been saying
One
for,
second.
I've been saying.
Let me grab a frame.
Hold on one second.
Sorry. Okay, I'm good.
Okay.
For the last 40 years that I've been involved with this reform movement, I've been saying in 5 years it's going to be legalized, you know. Fortunately, here in year 2011, I can say in about 6 months it's going to be legal in the United States, because I have great hope for our new administration led by the Democratic Party, and a person up from San Francisco area who is the Speaker of the House. And I have a strong sense that she recognizes the importance of ending these sanctions, of changing the scheduling of marijuana, and it's going to happen in the very near future. I don't have any inside track on that when and whether it's brewing or not, but I do have a strong feeling that the public will put up with it, and the public expects it, and they're really tired of the continued prohibition because it hasn't helped our society to continue in this fashion. And it still consists of the, quote, they said, the bread and butter of law enforcement, because it's, first of all, it's an inroad into someone's house for purposes of committing searches and things of that nature, because it creates probable cause. And that's a great tool to undercover other activities that people may be involved with, as well as arrest them for marijuana. So it's still a very serious drain on our law enforcement resources. Unfortunately, the number of arrests are going up every year. I understand last year is about 700,000 or more arrests for marijuana in the United States. And it's costing billions of dollars, not only in personnel and making those arrests, and beyond that, prosecution in the courtrooms, the cost of the court personnel, and the cost of jails. We understand that there's about 50% of the population in jails is drug-related. Smaller percentage of marijuana-related. But to give you one example of the shall we say, the outrageousness of these laws, that we have 35 people in California jails for life for serving just for marijuana offenses because of the 3 strike laws. 35 people that cost us $40,000 a year. It costs, and just add up those numbers alone, you can see how ridiculous it is. Those people are in jail because they had 2 prior strikes, admittedly, but they're serving this time because of only marijuana offenses like cultivation or sale or possession for sale. So it's costing billions of dollars throughout the United States to continue to prosecute marijuana cases and enforce the laws. It's costing our privileges under the Constitution regarding protections and searches from the police. It's costing also the credibility of the government when it comes to trying to combat drug abuse, because when the government's saying that marijuana is dangerous and people know that it's really not such a danger, then it undermines their credibility when they try to tell kids about speed and PCP, and more serious drugs. They just equate the whole representation by the government and the people that come to the classrooms, like their program, is just not being credible. So it defeats our attempt to really deal with more serious drugs. So there's many reasons why the continuation of the prohibition on marijuana is very costly to our society and a great detriment to all of us in so many ways. Beyond the fact that, don't forget, it's all black market, almost in all cases, except for the dispensaries and co-ops, which don't make profit. So this black market money goes into the hands of otherwise outlaws. And those outlaws use that money for other illegal activities in many cases, and fuels their ability to buy guns and do other things that might not have access to. So if we could get the marijuana out of the black market, it would certainly help, number one, with a tax base for the sale of marijuana, if there is, for sales taxes. It would also help with being able to control its use and control, in some sense, the protections of people that sell it and people that possess it, because if it's in the open, you can call law enforcement and say, that guy ripped me off for my pound of weed, go prosecute him, Much less apt to do that when you're potentially going to be prosecuted for that. And when it comes to trying to deal with youngsters using marijuana or other drugs, if you didn't have to worry about the law enforcement coming in or Department of Social Services, you could deal directly with your kid. Say, I'm going to take you down to the school principal and talk about this right now, why you shouldn't use this. But we can't do that because it's in the closet. And we're afraid to talk about it. We're afraid to confront it. We're afraid to admit our own marijuana use to our children because of the fear of prosecution and the retaliation in some sense. So there's so many reasons why this continued prohibition has really cost us in so many ways for so many years. It's got to stop, and I anticipate it will stop in the near future.
Okay. I was just going to ask him if he wants to. Is there anything else we haven't touched upon that you would like to say in closing?
Let's see your notes. You got any notes, sir?
Yeah.
Let me see them. Pinpointing exactly how marijuana helps patients in a physiological way is not always easy. But they have been able, as the studies come down, continually showing why it does affect certain conditions and why it is effective, like, for instance, the glaucoma and the wasting syndrome when you're using the age drugs, and myriad of other things, arthritis, and et cetera, et cetera. But beyond that, the attitude of the patients can be uplifted many times by using this sacrament, if you don't mind, or this medicine, and that can sometimes affect their overall health condition. So it's very important that we continue to protect patients' rights to use marijuana. But beyond that, as I've touched on earlier, in my mind, it's a constitutional and human right to be able to make these choices for yourself. The general principle of criminal sanctions is that you can do what you want to do as long as you're not harming others. And it's a great stretch to suggest that using marijuana is harming others, unless you do things like driving impaired, for example. But those laws will always remain in effect, and no one suggests they should. They should always have laws to protect others from activities that endanger others. But to have across-the-board illegalization and prohibition of marijuana is really irrational, not supported by medical science, nor anecdotal information regarding what's gone on with marijuana use. And there's no longer an excuse that the politicians can use it. We're still studying it. We don't know the effects of it. It's probably been studied and looked at more than any other drug you can think of in the last 30 years. There's been every type of analysis you can think of. And the government has sponsored many programs to evaluate the medical use of marijuana and its effects. And to this day, they've yet to come up with serious consequences that justifies the continued prohibition. And I think much of the chagrin of the governmental forces that are behind the continued prohibition. As a matter of fact, there were studies way back in the early 70s by LaGuardia, the mayor of New York. There's been studies. The Schaefer Commission was commissioned by, I think, President Nixon, all recommending that marijuana be decriminalized. But yet we have this old guard that's completely entrenched with the idea that marijuana is a dangerous drug and it's got to be somehow eliminated from our society. And of course, no matter how harsh these penalties have been, and they have been very harsh, and many people have suffered greatly, and many people are serving many, many years in prison, it hasn't defeated the availability or the continued use by a large portion of our society. They recently did a study in Boston, I understand, and they found out 20% of the adult population used marijuana in the last 30 days in Boston. That's a huge number. You're going to put all those people in jail? No. Obviously you can't, and it would be unjustified to do so. So myself and Normal stand for the proposition that the government does have a responsibility to investigate and analyze and research marijuana, to advise the public of the dangers of use of abuse, and to use their resources in educating the public in ways that keep people from abusing any drugs, and particularly marijuana. Although it's very seldom abused, there are instances where it can be abused, and people should recognize the signs of abuse. If the government would spend the money on education and providing programs of rehabilitation in lieu of these kind of law enforcement resources, we would be better off.